The Supreme Court heard arguments today regarding Louisiana Act 620, a bipartisan 2014 law protecting women's health. Just hours out of the courtroom, One America's Jenn Pellegrino has more from Louisiana Attorney General Jeff Landry.
We're here with Louisiana Attorney General Jeff Landry and Solicitor General Liz Murrill. Thank you both for joining me today. I understand you've come from the Supreme Court where you argued your case, June Medical Services versus Russo, the first major abortion case during Trump's presidency, and regarding Act 620. Can you tell us a little bit more about that?
Yeah, it's a great case. Very excited to be in front of the court today. This is an important case in determining state sovereignty and also to protect women's health care.
Specifics of the case, it requires doctors to have admitting privileges at a nearby hospital. Do any other states have this in place?
It's a great question, and appreciate you giving us some time, because you're exactly right. In all other aspects of healthcare in Louisiana, in these types of clinics, doctors in Louisiana are required to have admitting privileges. What the Louisiana legislature did several years ago was basically fold in. They recognized we have a hole in our public safety law in that we are not requiring doctors at abortion clinics, but everywhere else, to have admitting privileges. So we just folded them into the normal regulatory scheme. You would think that's common sense.
What kind of opposition are you facing? What misconceptions would you like to clear up for our audience?
Why we were regulating is probably the most remarkable difference in our case. For example, one of the doctors at the plaintiff's clinic, he is the medical director, and he hired an ophthalmologist and a radiologist to perform abortions. Wasn't doing any credentialing at all. This is a way of ensuring that there is credentialing of doctors who are working at these clinics against a backdrop of clear evidence that they don't do it and they aren't doing it.
And so you left the courtroom just a few hours ago. What was the outcome and what's next?
You have millions of different views, and until we get the opinion issued by the court, we don't know. However, just what we explained today, it seems commonsensical, right? If there are absolute distinguishable differences between Texas's law, which was ruled unconstitutional, and Louisiana's law, which was heard by the Supreme Court. I think just the fact that we were at the Supreme Court speaks volumes of the fact that the Texas law and Louisiana's law was distinguishably different. That's why the court decided to hear it. And it's about safety. It's about ensuring that people going into those types of clinics receive the same level of safety and care, and that those doctors are properly credentialed.
Well, please keep us posted. We'd love to have you back here in studio. And
we'll come back. Yeah, you let us know when they do. We'll come back.
Thanks for having. Thank you, Liz, Jeff.
Thank you.
Thank you for joining us.
Want to see more videos like this? Click on the link below and subscribe to One America News on YouTube. And call your cable provider and kindly demand that One America News is added to your lineup. Call and subscribe today.